One of the privileges of practicing law and having practiced law for 40 years is that you get a chance to see some great writing and some great intellects. And this is a shout out to John Shepard Wiley, a Court of Appeal justice, who is a Berkeley Law graduate and was attending Berkeley Law contemporaneously with me. And Justice Wiley wrote a frequently quoted opinion in April of this year. The case was Carton versus Airy Design and Construction. And Justice Wiley was faced with a claim for hundreds and hundreds of thousands of dollars in attorney's fees in a case for a prevailing plaintiff, in this case, Carton, who is a lawyer who had been representing himself. Justice Wiley reduced the amount of requested fees by over $200,000, and he had a few things to say that are articulated far better than I could. Justice Wiley said, excellent lawyers deserve higher fees, and excellent lawyers are civil. Sound logic and bitter experience support these points. Civility is an ethical component of professionalism. Civility is desirable in litigation, not only because it is ethically required for its own sake, but also because it is socially advantageous. It lowers the cost of dispute resolution. And I was in a call today with someone that is a renowned investigator that works with large firms, and she said that she gets people that specifically request a pit bull. They want somebody that interrupts, is aggressive, calls names, and makes it difficult on the other side. There's a problem with that. That is not good lawyering, even if the clients think that that's what they want. And in fact, some of the rules that have been enacted recently have reduced the crushing caseload on our judges in California, and in particular in Los Angeles Superior. The legislature required meet and confers prior to demurs, and that reduced the number of demurs. The statutes have long required meet and confers in order to address discovery disputes. And many judges now are having informal conferences before they go on the record with a full-fledged motion, which again is reducing the workload of the judges. So to be a lawyer that is considered excellent by the judges, what is it that you want to do? Well, first off, you're not doing your client any favors if the number of motions and the number of issues in the case multiplies needlessly, because the lawyers cannot communicate. And even if they don't like each other as people, do not get the record focused. The number one complaint I hear from jurors is that the lawyers take too much time on irrelevant matters that have nothing to do with anything. By being civil and by being focused, you respect the judge's time. Additionally, you want to know what the rules are for that particular department and show respect in that way as well. For example, a lot of times documents do not get delivered to the judge just because of the way the courthouse is set up. And you would think, well, in a world with electronic service, that problem is over, but it isn't, because the way that you scroll through the documents electronically can be very burdensome for the judges. So a lot of them say, we want courtesy copies. We want them this far ahead of the hearing. And you want to know what those rules are, and you want to inquire of the clerk, even if it's not expressly written down. In terms of controlling the record, in terms of having a record that makes sense. If you are too fast for the court reporter, you're going to be too fast for the judge, and you're going to be way too fast for the jury. If you interrupt, particularly on Zoom, you're going to get an absolutely terrible record. Excellent attorneys are civil. Excellent attorneys deserve higher rates. Excellent attorneys win at trial.